Hi, I'm Gene Trowbridge, and you found our YouTube channel. And the presentation we're going to have today is called Mistakes I Have Seen or I Have Made. And this presentation is good because as a syndicator, I made some of these mistakes, not all of them. And I'm alerted to mistakes my clients can fall into if they're not careful. And then I constantly see new mistakes that my clients are making. So this is interesting. As you can see from the slide, I was an active syndicator for a long time. And then at 45, I went to law school. And now I've been practicing law in the syndication business. All this time we write private placement memorandums. We're the people that you hire to go and get your securities work done. So, mistakes. Here are a couple mistakes that I think are prevalent today. First of all, the property doesn't provide current cash flow for distribution to the investors. In today's market, as we're speaking, you have to have the ability to provide cash flow to your investors, depending upon what you're doing with the project. If it's a stable project and you're not doing a lot of rehab or renovation, you probably need to start writing checks at the end of the second quarter after you buy the property. If it's a rehab property and you're going to do a lot of stuff or even build something, then you might not have any cash flow for 18 months or 2 years. That's fine. But just simply to go into a project where there's never going to be any cash flow, unless you're just a builder, building to sell, or just a flipper, that would be a mistake. Back-ending investor profits. Going to the market today with an offering where you're going to tell the investor, you're going to have to wait till the end, and that's where you get all your profits. Or back-ending the sponsor profits. Taking an offering to the market where you don't make any money, you don't get compensated for your work at all until the end of the offering is problematic. The investors don't want to wait for all their benefits to the end, and you shouldn't either. I'm not exactly sure an investor is comfortable with a sponsor who isn't making any money until the very end. How does that investor know that we'll keep your interest? That you'll continue to work in case certain things don't go as scheduled. So I think that's a problem. And then inappropriate debt structure, recourse versus non-recourse. For the most part, you don't have to take a recourse loan. You can find loans that are non-recourse. And so for the sponsors, I'm suggesting that in the rare instance where you have to take a recourse loan, think about that very carefully. But maybe a good business strategy on your part would be to only take non-recourse loans. Other mistakes. We've got some very creative syndicators out there who come up with real estate plays that are complicated, come up with waterfall schedules that are complicated, come up with ownership structures that are complicated. By the time it's all done, I'm not even sure that me as the security attorney understands it. And then I have trouble writing it. And if I don't understand it, your investors are not going to understand it. So don't make the deal so complicated that no one can understand it, because it'll just give them an excuse to say no. Trying to do a blind pool as your first offering. Now, what's a blind pool? A blind pool is where you don't know what property you're going to buy, but you know that you need money to buy the property. So you're going to go out and attempt to raise the money from your investors, and then you're going to go find a property. I'm going to suggest to you that my experience is that if you don't have a track record of buying properties like the ones you're telling your clients you're going to buy, and you're only going to do one property, you're not going to be successful raising money. And even if you are successful and you bring the property to them, you're going to have to give them a chance to change their mind. So you're going to sell twice. So I suggest blind pools or funds, whatever you call them, are good when you have a track record. You raise all your money up front, and it's an acquisition strategy is what it is. How are you going to compete with the other buyers that are all cash, the 1031 exchange buyers? How are you going to compete with that? Well, you're going to have some money. And so a blind pool for a syndicator with a track record is something that can be done, but not as your first deal. Giving the investors too much control is a mistake. New syndicators who aren't confident in their ability to raise money seem to think it's a good idea to let the investors vote on when do we refinance, when do we sell, who is the major tenant going to be. Well, that's why you're the syndicator. You're the expert. You're the one who's going to make the money by giving your investors good, sound real estate advice. My more experienced syndicators don't really let the investors vote on anything other than replacing the manager. That's the one thing I insist on in the offerings I write, that there's some language in there that does let the investors replace the manager, because things happen to managers that makes it very difficult for the investment to proceed successfully with that manager in charge. I'm not just talking about dying, although we've had that situation here in the last couple of years, but there are lawsuits, there are divorces, there's bankruptcies. Quite a while ago, I represented a syndicator who hit his head on a rock skiing up in Park City and came out a quadriplegic and spent a year in traction. Well, you can't run the business like that. So we had to replace that individual. And just as a side note, I don't think you should do an offering where the sponsor is just one person. I think you need to have continuity, more than one person, just in case something happens, to protect the investor, to protect the investment. Undercapitalizing the raise. My more experienced syndicators always add a couple $100,000, maybe as much as $500,000 to the raise, so they have plenty of working capital to offset the things that happen. Now, by raising that extra $400,000 or $500,000, it might change the IRR in your projections, but maybe in a smaller deal, you should only raise another $50,000, and it's not going to mean so much. But this is the time you can raise the money, when you're doing the deal, not 3 months into the deal when you find that you're short and you have to do a capital call. Capital calls, by and large, don't work. You can't force anyone to send you money. Even if you tell them, I'm going to take your whole ownership if you don't send money. If they don't want to send money, they're not going to. And given the situation, they might not want to send money, and they're just happy. There's no reason sending good money after bad money, right? Having inadequate insurance and reserves. So this kind of goes with undercapitalizing the raise. You have to have plenty of money in reserves in case you have an emergency. And then insurance. This is one of the things that I always say as an example. If I'm going to buy a property, I'm out here in Southern California. If I'm going to buy an apartment building, a high-rise apartment building with my own money, the question of life insurance is earthquake insurance is something that I can deal with. I can make a decision on my own not to get earthquake insurance. But if I'm representing 30 of you in a project, I'm getting earthquake insurance. I'm not going to be on the stand being questioned by some aggressive attorney at why the heck we didn't buy earthquake insurance to protect our major investment and all these investors out there. It's just the prudent thing to do when you're managing other people's money. Now, here are some bigger mistakes. Not having enough time to raise money. I think that you should have 90 days from the time you hire the securities attorney, you start your purchase and sale agreement, until it's time to close. In the first 30 days, you're trying to find financing, you're trying to get your legal documents together. In the next 30 days, you're going out there and trying to raise the money. And in the last 30 days, it all kind of comes together and you have a deal. Now, finding a 90-day escrow sometimes is difficult, I understand. So maybe it's a 60-day escrow with the ability to extend for 30 days. But if you're at 60 days, what you're going to find is that after the first 30 days, now you have all your paperwork ready. You just about have the financing ready. You only have 30 days to ask people for money, to collect their money, and get ready to close. And some people are going to feel rushed. Some people are going to think that there must be something wrong. How come we didn't plan a little better? And your money raising will suffer. 60 days is absolutely the minimum, but negotiate 1, 2, 3, 4 week extension, even if you have to let more money go hard to the seller. Taking investors' money before the investment LLC bank account is open. Investment LLC is what I call the LLC where all the investors invest in. It owns the property. It's the borrower. That's where the money has to go. You don't put it in your account. You don't put it in the manager account. You don't put the checks in your desk drawer until it's time to open the bank account. Get the bank account open as soon as possible. As soon as we start our work on our offerings with you, we will get the LLC set up. We will work with you on getting your tax ID number, and then you'll go to the bank. So you're all ready to take money as soon as all the investment documents are completed, and you can actually take money from investors in accordance with the security law. You need to not take any money before that time. And another offset of that is, where are you going to put the money? When you start taking money from investors, where are you going to put that? Are you going to put that money in some sort of an escrow account where there's a third party who has signing authority, like the seller? Sellers die, sellers get sick, sellers get divorced, sellers change their mind. You don't want the investor's money in an account where anyone other than you controls it. Open the bank account for Investment LLC, deposit the money in that bank account, and 3 or 4 days before the closing, just send enough money over there to close. If you're doing a rehab project, you may be raising $1 million or $2 million for CapEx expenses. That doesn't go in the escrow to close the property. You keep that. So that's just another thing about where the money goes that you have to be careful of. Paying finder's fees to anyone who doesn't have a securities license. The rule is, unless you have a securities license, you can't sell a security and you can't collect deal structure compensation. So you can't get paid. I see this happening a lot where sponsors go out and they find someone, Gene Trowbridge walks up to them and say, hey, I've got a group of investors. I like your deal. I could raise $1 million and put it in your deal, and I'd like you to pay me 2% based on the $1 million that I raise. Well, if I don't have a securities license, don't do business with me, because I really can't do that. And you can't pay me. If you do that, you're in a world of hurt. If the deal goes bad, I'm in trouble, because without a securities license, I sold a security. I'm going to get sued. I may be responsible for rescission, for giving the investor all their money back. And I never had their money. I gave it to you. You may be responsible for rescission, giving the investor all your money back, because you use an unregistered broker-dealer to raise money. So don't do that. The answer to that is, anyone comes to you and wants to raise money, bring them in your manager, LLC. Make them an issuer just like you. It's like a for sale by owner concept. If you're an issuer of the securities, you can sell the security without a securities license. But you can't get paid for doing that. You can take part of the promote and all that, but you can't get paid on a scale that changes depending upon how much money you raise. That's commission. That's transaction-based compensation. And you can't do that. Very big mistakes. Not having a plan for continuity. That's the first question I suggest any investor should ask the syndicator. If I give you my money, what happens if something happens to you? And in fact, our company has a policy that we won't write offerings if it's one single individual, even inside of an LLC, to be the managing member. Because if that individual can no longer conduct business, that LLC can no longer conduct business. The project can no longer conduct business. What are you going to do? That individual in that LLC is the only one who has sign-in authority. And what are you going to do? Go out and ask a passive investor to take on the risk? What's the lender going to say? You need to have at least 2 people, 3 or 4 is better, in the manager entity for continuity. The next thing that's a very big mistake is not having a plan for liquidity. What happens if something happens to me, the investor? See, I think there are 4 questions an investor should ask, and a sponsor should know how to answer them. Number 1, what's the continuity question? What are you going to do? How are we going to handle this? Number 2, you're going to get asked, have you done this before? So you used to have, or you must have, some track record or some personal experience you have had in this part of syndicating, so you can convince the investors they should invest with you. The third question is, are you going to have any skin in the game? Are you going to put any of your own money in the deal? And that's somewhat of a marketing question, but that's an important question. And the last question an investor should ask, hey, are your documents written in a way that if something happens to me, I can become liquid? And a well-written document has a liquidity provision for voluntary liquid. I want to sell. I want to donate. I want to gift. How can you deal with that on a voluntary basis? And then there's another section of the operating agreement that deals with when it's not voluntary, involuntary liquidity. You get sued, and in the lawsuit, someone wins all of your assets. You get divorced, and your wife or the spouse who's on the other side wants all of the assets, wants control over the assets. So we have clauses for that. It's easy to do that, but you have to know enough about the operating agreement and what you want in the operating agreement to protect your investors. So when they ask you the question, what happens if something happens to me and I need my money? You can point to the agreement and satisfy them, make them confident that you've got that covered. Now, here are the biggest mistakes. Drafting your own documents. If you're drafting your own documents, how do you know that those liquidity provisions are in there? How do you know that the continuity provision is in there? How do you know that the discussion of cash distribution on operations, which is different than on disposition, is in there? Don't draft your own document. It's the unauthorized practice of law. And in the court of law, you're going to be held to a standard of what is the practice in your community. And the practice in the syndication world, no matter what community you're in, is you have a lawyer draft the documents. Not reading and following your documents is another one. I can't tell you how many times I get questions of people coming and calling me, and they're asking me a question, syndicator, that if they were familiar with their documents, I'm not saying they don't read them, but if they were familiar with their documents, they wouldn't have to ask me the question. And what if it's their investor who asks them that question and they don't have an answer? What if it's the investor who finds a clause in the document and wants it answered. It's fine not to know the answers to the more detailed things and say, well, I'll have to check with the attorney. But for the most part, you should understand your documents. Now, I understand that all of a sudden you've got these documents and you've got 30 days to close and you want to raise the money as fast as you can. But wouldn't 4 or 5 hours of sitting with your documents, or maybe you've read your documents during the drafting stage and you know what they say, enough so that you can go to the marketplace, that might make some sense. Making cash distribution from reserves. Now, that in itself could be fraud. In your offering documents, you're telling the people that they're going to get a preferred return, a 6% preferred return on operations. And you get to the end of the quarter and you don't have enough money to give them 6%. So you reach over into your reserve account, which is set there to replace all the air conditioners, and you take some of that money and distribute it to the investors, and you tell the investors, here's our preferred return that we earned from operations. Well, first of all, that's not the case, is it? You're giving them some of their own money back. Preferred return should be a return on the investment, just like interest is at the bank. If you put your money in the bank and the bank promises to pay you 10%, at the end of the quarter, you go in there and you're going to get your share of 10%. They're not going to reach in your principal and give you a little extra so that your withdrawal is 10%, some interest and some principal. No, you can't do that. And once you start digging into your reserves that are designed to replace the air conditioners, you're going to find that when it comes time to do the air conditioner work, you don't have the money. And now you're going to go to your investors and you're going to tell your investors, well, I'm sorry, I don't have the money to do the air conditioner, which was part of the great opportunities we saw in this project, but I used it to fulfill the distributions to you. Those investors are going to be rightly disappointed. Most investors, if push comes to shove, don't care about the quarterly distribution. They want the project to work. They want their money back. They want all of their money back, and they want to make an earning on their equity at the end. And we'll come and go with the cash flow depending upon what we find and what is a surprise. Thinking you always have to have an offering on the street, this is a mistake I made. I was going to a conference, an international financial planning conference, and I was going to have a booth, and I knew there were going to be competitors, other people who were doing syndication, standing at their booth, pitching their offering to stockbrokers and registered representatives and financial planners who are going to be at the conference. And I didn't have an offering. So I rushed the due diligence on an offering so I would have an offering to present to the investors. And that turned out to be a problem. One of the things that investors think or syndicators think is if I don't have an offering on the street at all time, that investor will take his money and put it in some other offering, and then I'll never get the money from that investor back again. I'll lose that investor. Well, that may happen. But that's not as bad as jumping ahead into an offering and putting it on the street before it's ready, because you really think you have to have an offering on the street all the time. Another issue about that is many syndicators need to have offerings on the street so they get the acquisition fees so they can make a living and pay for the people who work for them. That's not a good reason to bring out a new offering. Not a good reason at all. So those are very big mistakes. Just as a segue on making cash distributions from reserves, just recently Jonathan and I were approached by an investor who said that his syndicator is now selling new units in the offering. This offering's been closed for about 2 years, selling new units in the offering. and is going to use the money from the sale of the new units to make quarterly distributions. That's a Ponzi scheme. That's illegal. And the sponsor said, when confronted, well, I told everyone what I was going to do. That doesn't make it right. That doesn't make it legal. Okay. A theory in law is if you're given permission to do an illegal act, it's still an illegal act. So don't do that. So those are mistakes that I have seen or I have made. And in the book, in my book, it's a whole new business, and the 4th edition is out. It's available on Amazon. You can search the title or my name by the hard copy or the Kindle. We do talk about mistakes that I've seen or that I've made in one of the chapters. So that'd be a good resource for you to have. So once again, I'm Gene Trowbridge, founding partner of Trowbridge Law Group. You can contact us, Jonathan, my partner, or myself, by calling our direct number to the office. You can go to our website, trowbridgelawgroup.com, and get a free 30-minute consultation with us. Sign up with an appointment. And certainly hope that you found this valuable and you will subscribe to our YouTube channel and look at all the information that's available for you right here. Thanks for your attention. We'll see you next time.